Hello, everyone, and thank you so much for joining us here today for our Friday weekly webinar. Today, we're going to be discussing on asylum updates, and this is for both affirmative and defensive, so it applies to both, which is awesome. Today, we have attorney Cynthia Milian giving us the updates on what's going on with asylum right now in courts and all that fun stuff. So a little bit on our associate attorney here. Thank you so much for joining us, of course. She focuses on family-based and removal defense immigration. So she is top, totally understands, guys. And she is also the vice president of MABA, the Mexican American Bar Association of Houston. She does pro bono attorney for the Montgomery County Immigration Law Clinic, and of course, fluent in Spanish. I'm gonna let her take it away with the learning objectives. Thank you so much for joining us again, Attorney Milian.
Thank you, Dana, for that introduction. And so we're going to go ahead and get started with what we are going to discuss. We're going to talk briefly about asylum law changes, proposed changes that came out last week. What is the status of the Migrant Protection Protocol or the Remain in Mexico policy, prosecutorial discretion, the changes that we've seen that and how that affects some asylum cases, and what you can consider after you win asylum. You know, if you want to bring derivatives or family members abroad, how that works. All right, so let's start with some changes. One of the biggest changes that we saw a couple of weeks ago was that the Attorney General issued a decision overturning matter of AB. I know that we may have talked about this some in the past, but I wanted to address it again. So this was huge. It was something that occurred earlier this year under this administration. And what this case did, basically, it gave the adjudicators or people that are seeing an asylum application, whether it be a judge or an officer at an asylum office, it gave them the ability to adjudicate an asylum application in favor of someone if they are fleeing their country due to gender and family-based persecution. And the more broadly, what this did is basically it gave the opportunity for individuals that are fleeing to establish that there could be persecution by non-state actors. So what that means is that by an individual that's maybe not working for the government, but is acting under the acquiesce of the government, where the government doesn't do anything to stop them from harming an individual. So the way that the law stands now is that they are going, adjudicators should follow the law as it was established pre-matter of AB. So the case that controlled was matter of ARCG, which was a precedential decision that basically provides a framework to determine asylum eligibility for women fleeing gender or domestic violence. Another change that we saw last week is that there's a proposed rule, and this rule, what it's basically doing, it's aiming to place asylum seekers, that have been in years-long case backlogs. So basically what this proposed rule is doing is it's going to give asylum officers more discretion to issue asylum grants. So usually when a person enters the US, if they enter without valid paperwork, they go through a process that's called having a credible fear interview. So they go through that interview to see if they've established that they are eligible for asylum. And if so, then they go through the next step, they're placed in removal proceedings and have to file an asylum application. And so this proposed rule basically gives asylum officers more discretion to rule and adjudicate asylum cases, and basically instead of having the credible fear interview and an asylum application, basically it makes it so that through that credible fear interview and with the credible fear finding, they can adjudicate an asylum claim. And it's also it proposes to give asylum officers the ability to either grant or deny withholding of removal and convention against torture. And these are two benefits that are only given by judges now. So this is a proposed rule that was published in the Federal Register. The public comment period is open for 60 days. So if you have any thoughts in favor or against it, then you are welcome to submit those comments. Another change that we've seen recently, the status of the Migrant Protection Protocol. So on Tuesday of this week, the U.S. Supreme Court basically denied President Joe Biden's decision or to rescind an immigration policy that was instituted by the previous president, Trump. And migrant protection protocol, like I mentioned in the beginning, is the case where it basically said that an individual that is seeking asylum must remain in Mexico until they have their hearings here in the U.S. And once they have hearing, then they're paroled in and then sent back. So this administration tried to get rid of that, and there were several judges that basically said that this is a process that should continue. Well, eventually made it up to the Supreme Court, and the Supreme Court says that yes, this should continue, and migrant protection protocols is back in place. So this is not great news, but we are going to continue to monitor and see, what the next step is going to be. Another thing that happened earlier this week, right, is prosecutorial discretion and asylum in court, right? So prosecutorial discretion is something that we've talked about in the past, and it's something that gives the Department of Homeland Security's Office of Chief Counsel discretion on what priorities they're going to have, what are their enforcement priorities, and whether or not they're going to pursue a removal case against a person or not. So there was a memo that was issued in May of this year that basically gave that discretion back to the Department of Homeland Security's Office of Chief Counsel. And, a lot of attorneys all over the US were, very happy about this, because this was something that was essentially taken away under the previous administration. And through this prosecutorial discretion, the way that it was benefiting asylum seekers in court was that, you could get the Department of Homeland Security to stipulate to an asylum grant, or to stipulate to a finding of past persecution, or recognizing a particular social group, so that it made it easier once you went to court to, narrow the issues that you were going to argue. But, on August 20th, earlier this week, there was a preliminary injunction that was issued in Texas that basically made the Department of Homeland Security suspend their reliance on the Trasvina memo, the memo that basically revived prosecutorial discretion. And so, as of right now, we've submitted requests, and the local office here in Houston is not, looking at those now. The stay of the injunction is until Monday, so we're waiting to Monday, August 30th, to see what's going to happen. And we hope that, it remains, that maybe this is something that'll be something that they'll re-implement, and that the Office of Chief Counsel would join in on prosecutorial discretion requests, either on motions to terminate, on motions to stipulate to certain things, to essentially make, fighting a case easier and a little bit more efficient. So it's something that we're monitoring on a day-to-day basis. Attorney Powers and myself were on a phone call last night until very late, getting last-minute updates on this. So if you have any questions on this, call our office so that we could talk to you about how you can benefit from it and what we can do to help you out. And another thing that we want to talk about, another update, it's work permits for asylum seekers. So as you recall, in August of last year, there were some new policies that went in effect for asylum seekers, right? People that were seeking asylum had to wait, instead of 180 days to apply for a work permit, they had to wait 1 year. And if they filed for asylum late, or if they didn't have a lawful entry, then they were not going to be eligible for a work permit. As of now, the only way that you can be subject to the old rules, right, where you can apply for a work permit 150 days after your application has been pending, and if you filed outside of the 1-year filing deadline, you could still qualify for a work permit. The only way you can still qualify under those rules is if you're a CASA or an ASAP member, and I've left the links here for you if you want to join. And it's free of cost. It's something that we don't do ourselves. You have to go to those organizations to get the work permit. And we've been successful in getting some clients work permits based off of their membership with CASA and ASAP. So definitely consider that if you've recently filed for asylum. And another thing to know for work permits, if you were to have gotten asylum through immigration court, there is a way for you to get the I-94, right? And even, proof that you did get asylum, right? Sometimes, while it's not required, right? If you're an asylee, you have the right to work. You have an automatic right to work. Some employers may want proof of that though. So if you ever find yourself in a situation like that where you have one asylum, just know that you can get an I-9, if you have one asylum in court, to clarify, then there is a way that you can get an I-94 through an InfoPass appointment with your local field office. So also information that you should be aware about. And if you have questions on that, give us a call to see how we can advocate on your behalf. Now, let's talk about what happens after you win asylum, right? And what changes and updates we've seen there. So if let's say that you gain asylum, right, and you have family members that are maybe still abroad or that are not with you because you could only get yourself out, or if you have all your family members here and you've gotten asylum and it's been over a year now, just know that you can apply for residency 1 year after you've been granted asylum. But when you are applying for residency, just make sure that you always disclose, if you belong to a particular social group, if you were part of a political organization, if you were arrested, if there's any arrest warrant out there for you, because you don't want these security questions to be something that prohibit you from becoming permanent resident. So after you apply for asylum, you don't just forget about what you disclosed in that application. That's information that you're going to have to continue to disclose in any other future form of relief here in the US. So be very careful with those security questions, because we've seen some people get requests for evidence and even notices of intent to deny when they haven't disclosed past arrests that they have disclosed in an asylum application. Remember, they're two separate and you must disclose it at all times. You're not required to apply for residency after your asylum grant, but it's something that you should consider. And then just know that you can apply for US citizenship. Usually it's 5 years when you're not married to a US citizen, but as an asylee, you can apply for US citizenship 4 years after you've become a permanent resident. So the way that is that you don't have to wait 5 years. 4 years after you became a permanent resident, then you can apply for residency. They basically backdate it 1 year. And then there's the follow to join applications. In the scenario that I talked about earlier, if you have family members, if you are an asylee and you have family members that are outside of the US, then you can file something called an I-730, which is an asylee or relative petition. And that is something that you would submit, but you have to establish proof that the relationship existed, whether a spousal or parent-child relationship existed before you were granted asylum, right? And we've seen, some updates with this, is that we've seen a lot of issues. A lot of times in different countries, people register birth certificates, a few years after the child is born. And we've gotten requests for evidence from USCIS stating, this isn't enough to prove that this person is your child. What makes us believe that, you didn't register, you just registered them recently so that they could derive these benefits. So you have to find, secondary evidence to prove that in the form of maybe affidavits from people that can attest to that child being your biological child, or even, school records that show that you were listed as the father, when the child was in kindergarten or the equivalent of that abroad. So just keep that in mind, and keep in mind that, once you file the I-730, which is the petition to establish that relationship with the asylee and the family member, that you should continue to gather information, because ultimately, the individual is going to have an interview at a consular post abroad, and they may ask more information or more bona fides to show that that relationship exists. So you should continue to gather that information. And just know that there's long processing times for that. Expedite requests are available, but they're on a case-by-case basis. And, the standard to get them, is pretty high. You have to show the humanitarian reason for it and the proof for it as well. We've been successful in getting some, but they have to be heavily documented and compelling. And as a reminder, if you are an asylee, you're not a resident yet, then you do need a traveling document, a refugee travel document, to leave the US. And you should always be careful. If you've won asylum, you don't want to return to the country from which you feared persecution, because that could be an issue at your residency stage or even at the naturalization state, right? That could call into question your asylum claim. So be careful of that. And that is it for now. If anyone has any questions, you can drop them below and we can follow up. And I'll pass it over to Dana now.
Thank you so much, Attorney Leon. And yeah, well, if, like she said, if you all have any questions or if you have an immigration case that's pending and it's an asylum case and have some questions, or someone who you may know who is having some troubles or having some questions, please do not hesitate to reach out to us. Again, we do make these videos bi-weekly on different immigration topics. The next topic that we're going to discuss is employment immigration options. So if that's something that you're interested in, I'll be dropping down the link down below so y'all can register in advance. And again, you can find these videos on our Facebook Live and our YouTube videos. And again, check us out on our social media. We post regular updates on immigration and trending news. But that'll be all for today. Thank you all again so much for joining, and we'll see you all on the next one. Thank you.